I have to be honest, when I first looked at this case file, I thought I was reading the treatment for a telenovela.
Oh, absolutely.
You have a powerful politician, a governor with, what, three different
Three
marriages?
marriages, yes.
Yeah.
A divorce in Hawaii back in the 70s.
And then, children from the first marriage, fighting the third wife. It explodes the moment the governor dies.
It does have all the elements of a primetime drama, doesn't it?
Mm-hmm.
But what's incredible about the life of Felicity San Luis
Mm-hmm.
is that the messiness of his personal life, it actually forced the Philippine Supreme Court to write a masterclass on family law.
And that's what we're digging into today. We are looking at the case of San Luis versus San Luis.
Giarno 133743.
Right. And our mission here is pretty specific. We're not just here for the family feud. We're looking at how the law handles two very specific, very tricky questions.
Two huge ones.
One is about geography. Where do you legally live? Is it where you vote or where you sleep?
And the other is about capacity. Can you be single in the eyes of the U.S. government, but still married in the eyes of the Philippines?
These are questions that affect thousands of people, not just politicians. But in this case, the stakes were incredibly high. We're talking about the estate of a governor.
Exactly. When Feliximo passed away in 1992, his third wife, Felicidad, filed a petition to settle his estate. She wanted to be the administrator.
So basically, the person holding the keys to the castle.
That's the one. And the children from his first marriage, Rodolfo and Edgar, they immediately said, absolutely not.
They didn't just say she was a bad manager. They attacked her on technical grounds. They said she filed in the wrong city, and maybe more hurtfully, they said she wasn't even his wife at all.
And that's the roadmap for our deep dive. A battle over venue, should this be Laguna or Makati, and a battle over standing. Is Felicidad a legal spouse or not?
Okay, before we get to the legal boxing match, we need to understand the players. Because Felicimo's timeline is, well, it's a lot.
It is the root of the whole problem. Let's just walk through it. 1942, Felicissimo marries his first wife, Virginia. They have 6 kids.
Including the 2 who filed this lawsuit.
Right. Virginia then passes away in 1963.
Okay, so far, a standard tragedy, a widower with kids, but then comes marriage number 2.
Right. In 1968, he marries Mary Lee Corwin. She's an American citizen. They have a son, but the marriage doesn't last.
And this is the pivot point.
It is. Mary Lee goes to Hawaii, files for a divorce, and gets the decree in 1973.
And this is where that legal gray area starts to creep in. Felicissimo is Filipino. Mary Lee is American. She gets a divorce in the U.S.
And he assumes, okay, I'm single now.
So in 1974, he marries Felicidad Sagalongos, our respondent in California, and they stay together for 18 years.
18 years. A lifetime. But when he dies, and Felicidad goes to court in Makati, the children from the first marriage step in. Their first attack was all about geography.
They said, objection. Our father was the governor of Laguna. He is a Laguna man. This case belongs in Laguna.
And on the surface, you can kind of see their point, can't you?
Yeah, I get it. If I'm the governor of a province, I'm the face of that province. I vote there. I work there. Why would the court allow the case to be filed in Makati?
Well, this brings us to a really fascinating legal distinction between residence and domicile. The children were leaning heavily on election laws.
Things like Nouvelle and Romualdez.
Exactly. And in the world of elections, residence and domicile are treated as the same thing. Meaning domicile is this very heavy concept. It's not just where you sleep. It's your fixed, permanent home. It's the place you intend to return to, no matter where you wander.
I see. So to run for governor, your domicile has to be Laguna. You can't be a carpetbagger from Manila just showing up to cut ribbons.
Precisely. The law is strict there. So the children argued. He was governor. His domicile was Laguna. Therefore, his residence was Laguna. Case closed.
But the Supreme Court said, not so fast.
Justice Yanare Santiago, who wrote the decision, made this crucial distinction. She pointed out that under Rule 73, Section 1 of the Rules of Court, the rulebook for settling estates, the term resides, does not mean domicile.
Wait. So the law has 2 different definitions for the word resides, depending on the kind of case. That feels like moving the goalposts.
It's more about the purpose of the law. Think of it this way. Election law cares about your political allegiance. That's domicile. Estate law is practical. It cares about convenience. That's residence.
Okay.
The court said resides should be interpreted in its popular sense. Where do you physically stay? Where's your toothbrush?
So it's the difference between your hometown on Facebook and your actual current city.
That is a perfect way to put it. And this is where the evidence Felicidad brought in became, frankly, undeniable and a little hilarious.
Oh, I loved this part. It wasn't some high-minded legal argument. It was basically a recycling bin full of paperwork.
It's amazing what leaves a paper trail. She had billing statements from the Philippine Heart Center and Chinese General Hospital.
And where did they send the bill? 100 San Juanico Street, Ayala, Alabang.
She had his membership records for the Ayala Alabang Village Association. It's hard to argue you don't live there when you're paying homeowner dues.
And my personal favorite, she produced letters that the petitioners themselves, his own kids, had sent to him. And guess what address was on the envelope?
Alabang.
Exactly. It's a bit rich to stand in court and say, he never lived in Alabang when you're mailing him birthday cards there.
And the final nail in the coffin was his calling card.
Right. It listed Laguda as office and Alabang as home.
That calling card really sums up the legal ruling. A person can have a political domicile in one place, the office, and a physical residence in another, the home.
So, since he lived in Alabang, which was under Makati's jurisdiction, the venue was correct. The children lost the geography battle.
Round 1 goes to Felicidad.
Okay, so the court agrees she filed in the right building, but as soon as she steps into that building, the children drop their nuclear option. They stop arguing geography and start arguing identity.
This is the heavy hitter, the capacity argument. They claimed her marriage to their father was bigamous, void, illegal.
And that logic goes all the way back to Mary Lee, the second wife.
It does. Their argument was a strict reading of Article 15 of the Civil Code, the nationality principle. It says that laws on family rights and duties bind Filipino citizens even when they're living abroad.
So because the Philippines doesn't have divorce, a Filipino carries that no divorce rule on their back wherever they go.
That was the traditional view. The children argued, Mary Lee got a divorce? Sure, that might work for her, an American. But Felicissimo is Filipino. Our law says he's still married.
So when he married Felicidad, he was technically committing bigamy.
Which creates this bizarre limping marriage.
A husband without a wife.
It's a legal absurdity. And that is exactly what the Supreme Court addressed by invoking the Van Dorn Doctrine.
This is from Van Dorn versus Romillo, right? A huge deal in Philippine law.
It is the game changer. In that case, the Supreme Court ruled that when a foreigner gets a valid divorce abroad, they were released from the marriage. And if they're released, the Filipino spouse must also be released.
Because you can't be married to yourself.
Exactly. The court said it would be discriminatory to hold the Filipino bound to the marriage while the alien spouse is free to remarry.
Huh?
It violates basic fairness.
It's the court saying, we aren't going to let our own citizens be victimized by our own laws.
Correct. The Filipino spouse should not be discriminated against in their own country. So, applying that to our governor, Mary Lee's divorce was valid for her. It freed her. Therefore, under Van Dorn, it freed Felicissimo too.
But the children, and I have to give their lawyers credit for creativity, they tried to use the calendar as a weapon.
The non-retroactivity argument.
They said, hey, this rule was codified in the Family Code, Article 26. But the Family Code was enacted in 1988. Dad married Felicidad in 1974. You can't apply an 88 law to a 74 marriage.
A classic legal argument. But the court shut it down on 2 levels. First, they said the Van Dorn Doctrine wasn't inventing a new law. It was just interpreting the basic concept of justice that already existed.
So the Family Code just wrote down what was already true.
In a sense, yes. But the court went further. They said the Family Code is retroactive. Article 256 says the code applies to past events, as long as it doesn't impair vested rights.
Vested rights. That sounds like a financial term. What does it mean here?
A right that's fixed and can't be taken away. The children basically argued they had a vested right to their father's non-divorced status.
That's stretched.
The court thought so too. Recognizing Felicissimo's capacity to remarry doesn't steal any property from the children that was already locked in. So Felicidad wins on venue. She wins on the theory of the marriage. Sounds like she's won the war.
But not yet.
Not yet. And this is where the show takes a turn into the painful reality of legal procedure.
The red ribbon nightmare.
Exactly. The Supreme Court said, Felicidad, we agree with you on the law. If Mary Lee got a valid divorce, then you are the legal wife. But you haven't actually proved that she did.
Wait, I thought everyone knew she got divorced. The kids talked about it. Felicidad talked about it. It was in the case documents.
Knowing it and proving it are 2 different galaxies in a courtroom. The court cited Garcia v. Riccio. You see, Philippine courts don't take judicial notice of foreign laws.
You can't just tell the judge, trust me, judge, this is how they do it in Hawaii.
No. You have to treat that foreign law like a fact. And Felicidad just presented a photocopy of the divorce decree.
And the court said, nice try, but that's just a piece of paper.
It's brutal. To prove a foreign document, you need an official publication or a copy attested by the legal custodian. And here's the hurdle. It must be accompanied by a certificate from a Philippine consular officer in that country.
The authentication process,
Yeah.
the seal.
It's a bureaucratic chain. The clerk in Hawaii signs it. Then the Philippine consul in Honolulu certifies that the clerk is actually the clerk. That consular seal is the magic ticket.
So, because she didn't have that sticker from the consulate, the Supreme Court sent the case all the way back down to the trial court.
Yes, they remanded the case. They basically said, go back to start, get the certified documents, prove the divorce happened under Hawaiian law, then come back.
That sounds exhausting. We're talking about documents from 1973. It's now the late 90s, early 2000s. What if the records are gone?
That is the terror of litigation.
Yeah.
But this leads to what I think is the most important part of this whole decision. The court threw Felicidad a lifeline.
A safety net.
A massive one. The court ruled that even if she fails to prove the marriage, let's say she just can't get that consular seal, she still has the right to file the petition.
How? If she's not the wife, isn't she just a stranger to the case?
She is an interested person.
Let's unpack that. It sounds vague.
To file for letters of administration, you don't have to be a spouse. You just have to be an interested person. That means someone who has a direct material interest in the estate.
Usually that means money.
It means money. And Felicidad has a money interest because of the 18 years they lived together.
The co-ownership concept.
Right. We have two articles in play here, Article 144 of the Civil Code and Article 148 of the Family Code. It gets a little technical, but basically, even if a marriage is void, people who live together and build up assets together have rights to those assets.
So if the divorce was valid, there was no impediment to their marriage.
Right. And in that case, Article 144 applies. The law presumes everything they acquired is co-owned, 50-50. She owns half.
And if the divorce turns out to be invalid, if he really was a bigamist,
then Article 148 applies. It's a bit stricter, but the point is, her 18 years of living with him gives her what the law calls a prima facie interest.
at first glance.
On the face of it, yes. She doesn't have to prove she owns every specific chair right now. She just had to show enough to get her foot in the door. The fact that she lived with him and they acquired property meant she was a business partner, if not a wife.
That is huge. It completely transforms the argument from is she the wife to is she a stakeholder?
It really does. It emphasizes that relationships have economic consequences, marriage license or not. She isn't begging for an allowance. She is claiming her equity.
It feels like the court was trying to find a way to be fair, despite the procedural mess.
I think so. They quoted a maxim, law and justice are inseparable. If applying the strict letter of the law leads to an obvious injustice like kicking out a partner of 18 years, then the law isn't doing its job.
So if we boil this whole thing down for our listener, what are the big takeaways?
I think there are three critical lessons. First, geography.
Don't confuse where you vote with where you sleep. For estate purposes, it's about physical residence.
Second, the Van Dorn Doctrine is the shield for mixed marriages. If you are Filipino and your foreign spouse divorces you, you are free.
And lesson 3.
Property rights can save you when marriage laws fail you. That interested person safety net is real. Your financial partnership in a relationship counts.
But, and this feels like the real warning here, don't rely on the safety net if you don't have to.
Please don't. Which brings us back to the red ribbon. Yes. If you have a foreign divorce, a foreign marriage, get it authenticated now. Don't wait until someone dies. Because as we saw here, the difference between knowing you're divorced and proving you are divorced is about 10 years of litigation.
It's a sobering thought. We assume our life history is obvious. Of course I'm divorced. But a judge only knows what you can prove with a stamped, sealed piece of paper.
It is the bureaucracy of truth.
Well, on that cheerful note about paperwork, I think we'll wrap up this deep dive. It's a reminder that even in the dry world of civil law, there are incredibly human stories.
Absolutely.
Thanks for listening. Go check your documents. We'll see you next time.